Well, welcome to the Cinnabar. Now, it's been 10 months since this disastrous Measure 114 gun control bill was passed in Oregon, and Oregon gun owners are still in limbo. So today we're going to give you an update on where the court cases stand and some potentially explosive information that's just come out from the Oregon State Sheriff's Association in the form of guidance that they're giving local law enforcement in case this terrible measure ever becomes enforceable. Now first, let's talk about the two lawsuits that are running concurrently challenging the constitutionality of Measure 114. And the first is in the federal court system, where it's challenging it on the basis of the Second Amendment to the U.S. Constitution. The second, in neighboring Harney County, is going through the state court system, challenging it on the basis of the right to bear arms portion of the Oregon Constitution. Now, while it's going through that system, Judge Robert Rescio, next door here in Harney County, has granted an injunction against the implementation of the entire measure until it makes its way through that system. Unfortunately, in the first round of the federal case, freedom-loving Oregonians took a beating when Judge Karen Emmegert basically regurgitated every argument that the state put forward in favor of Measure 114 in her ruling. Now, of course, we have two major components of this measure, and there are some other minor ones that are troubling as well. But basically, we've got a permit to purchase scheme and a large capacity magazine ban. Now, on the permit to purchase portion, her ruling says that the permitting process imposed by ballot measure 114 does not violate the Second Amendment because it is a permissible, shall issue permit system analogous to those in many other states. And then goes on to say that it doesn't violate the Fifth Amendment as an impermissible taking by the government or the 14th Amendment guarantee of due process. Okay, so perfectly constitutional, in her opinion, to have a permit to purchase scheme. On the issue of the large capacity magazines, she had 5 points that she made about the constitutionality. And first, she found that large capacity magazines are not arms protected by the Second Amendment. Second, found that large capacity magazines are not in common use for self-defense. That's a little mystifying. Found that large capacity magazines have features that make them unusually dangerous. So if they have 10 round capacity, they're not unusually dangerous, but if they have 11, they are unusually dangerous. And the restriction on large capacity magazines is consistent with our nation's history and tradition of firearms regulation. That's a bit of a stretch as well, and found that large capacity magazines represent a dramatic technological change from historical firearms, as if there haven't been magazines capable of more than 10 rounds for many decades. Now, I'm sure most people who watch this channel would agree that that ruling resembles something we normally see come out the south end of a northbound bull. And so did the plaintiffs. It was immediately appealed to the Ninth Circuit Court of Appeals. And we always knew that no matter which way it went, that it would be appealed to the Ninth Circuit. It would have been nice to get a favorable ruling in that first round, though, so that the law or the measure couldn't be put into effect until there was a final ruling from the Ninth Circuit. And of course, we expect that whichever way it goes there, it will be appealed to the Supreme Court. Whether they take it up or not is anybody's guess at this point, and that could take years from now. Now, we're hopeful for a much more favorable ruling from Judge Rescio in the state lawsuit taking place next door in Harney County. He has come across as very favorable to gun rights in the past, and we would expect him to hopefully rule in our favor. The problem is he won't have the final say. Of course, we know that even if he rules favorably for gun rights in Oregon, that it will be appealed immediately by the State Attorney General. And it's a little unclear at this point whether it would go to the Oregon Court of Appeals or be appealed directly to the Oregon Supreme Court. Our AG has twice now tried to subvert the process and take it out of the hands of circuit court judge and take it directly to the Supreme Court. Both times our Supreme Court, rather surprisingly, has ruled correctly to let it go through the process. Now, I don't know that we can draw a conclusion that they're going to rule in our favor because of that. I think our Supreme Court is very, very liberal. Most of them have been appointed by our liberal governors over the past 10 to 20 years, and so I would not expect a favorable ruling there. So at some point, we will most likely lose in the state court system the higher it goes through the system, and the measure then would be put into law and be enforceable. And because we lost the first round in the federal court system, there's nothing in that system that would preclude that from happening. Now, hopefully, maybe the folks that have appealed this to the Ninth Circuit could get the Ninth Circuit to put an injunction against its implementation, but that's for better legal minds than mine to guess about. Now, at the beginning of this episode, I alluded to a new twist that could have potentially a dramatic impact on this whole mess. And I found this on the Oregon Firearms Federation website. Now, OFF has been just a stalwart in this fight. They filed the first lawsuit, and they fought tirelessly for Oregonians' firearms rights. And they deserve our support. They continue to put up the good fight, even as this thing goes to the Ninth Circuit Court of Appeals. Now, this is a link from the OFF website to guidance that the Oregon State Sheriff's Association is giving to their members, the county sheriffs, the local law enforcement. And in Measure 114, these are the people who are tasked with providing these permits, these purchase permits for citizens who want to buy a firearm in Oregon. Now, they say that there are 8 hoops we have to jump through in order to be approved by the state to purchase a firearm, which is just amazing to me that we're still in the United States of America. But anyway, there are 7 of them are attainable, and the 8th is not. The 8th step is an FBI background check. So we have to pass an FBI background check as the 8th and last step to get our permit. However, the FBI has told the Oregon State Police that they flatly refuse to do those. Now, whoever wrote this piece of garbage measure didn't even do the homework to understand how the background checks are conducted. They're conducted by the Oregon State Police. Now, they have access to federal databases in order to help them complete that background check, but the FBI doesn't do those background checks, and they're not going to. So, what the Oregon State Sheriff's Association is telling local law enforcement is this. And this is in very bold print. Our guidance on this issue is clear, unambiguous, and simple. No permit agent should issue a permit to purchase a firearm unless the Oregon State Police reports that the person is fully qualified to obtain a permit, including that they have successfully passed the required FBI background check, which we can't do. There can be no more clear violation of the Second Amendment to the U.S. Constitution than to tell the entire citizenry of the state that no matter how qualified you are to own a firearm, you cannot because of this Measure 114. Okay, then it goes on to discuss the actual wording in the measure that makes this so, about the FBI background check. And then in conclusion, they write, "It is apparent that without a required background check, no permit agent could determine that the applicant has met each of the qualifications because the FBI check is one of the specific qualifications listed in the measure. Issuing a permit to purchase to a person who is not fully qualified, including the FBI background check, would violate the requirements of the measure and would be unlawful." So what they're telling local law enforcement who are tasked with issuing these permits is that it would be unlawful to issue a single person to a single citizen of the entire state of Oregon. Okay, so let's hear what the Oregon State Sheriff's Association's guidance is on the dreaded large capacity magazines. Any magazine capable of holding more than 10 rounds of ammunition. And the measure is quite clear on all the different types of magazines that would be banned if they hold more than 10 rounds. Fixed or detachable magazines, belt, drum, strip, feed strip, helical feeding device, similar device that has an overall capacity or that can be readily restored, changed, or converted to accept more than 10 rounds of ammunition. So not only can it not hold more than 10 rounds of ammunition, it can't be in any way modified to be able to hold more than 10 rounds of ammunition. Okay, which pretty much rules out any kind of magazine. Now it does, on tubular magazines, exempt 22s and lever action rifles, but not all tubular magazines are exempted. Shotguns, for example. If you have a shotgun that's tubular fed, and most are, because we have access to these shorty shotgun shells now that are commercially available, almost any shotgun with a tubular magazine can hold more than 10 rounds of those short cartridges. Okay, slide action rifles. I did an episode before about these Colt Lightning rifles. Any of them that aren't antique would be banned under this measure. Okay, now it does say that if we permanently alter these magazines, an ammunition feeding device that has been permanently altered so that it is not capable now or in the future of accepting more than 10 rounds of ammunition is legal. But if you have the skill set to alter that magazine to where it can't hold more than 10 rounds, you certainly have the same skill set to be able to alter it back. There's no permanent way to alter a magazine one way and not back the other way. That's ludicrous, and I think by design. And so basically they've outlawed all magazines in Oregon, the possession of all magazines, except for 22s and lever actions with tubular magazines. Now, they wanted us to make us feel really good that they weren't going to make us give up any of the arms that we already had. So they grandfathered in, if you already own your large capacity magazine when the measure takes effect, you can keep that. Well, let's see how that works out according to the Oregon State Sheriff's Association. It says perhaps the most important issue regarding large capacity magazines is the fact that the measure makes the use, possession, or transfer of a large capacity magazine a crime subject to some narrow exceptions for gun dealers, manufacturers, police, and military. Okay, whether you owned it or not before this measure took effect, it is still a crime, but the burden is on you to prove that you haven't committed a crime, and we call that a affirmative defense. Now the precept in America and the American justice system is that we're innocent until proven guilty by the state. But under an affirmative defense, it's just the opposite. If you're caught with this large capacity magazine, you are guilty. But you'll have the opportunity to prove to a jury of your peers that you fit into these exceptions. Now, listen to these exceptions now. What make it legal to possess these if they were grandfathered in. The affirmative defense applies only to the following. The large capacity magazine was owned by the person before the effective date of the act and maintained in the person's control or possession. Okay, so you have to prove that not only you owned it, which is almost impossible to start with because they're not serialized. Not only did you own it, but it has stayed in your possession 24/7, 365 since the measure went into effect. How do you prove that? How do you prove your buddy didn't take it over across the road and shoot a deer with it or something? Okay, and this was even better. The possession of a large capacity magazine was obtained by a person who on or after the effective date of this section acquired possession of the large capacity magazine by operation of law upon the death of the former owner. So in other words, if you inherit one of these large capacity magazines, it's okay. But that person has to be able to prove that in their lifetime they kept possession of it and kept it in a manner that made it legal to continue to be in possession of. But that person's dead. How are they going to prove that on your behalf to a jury? I mean, it's nonsensical in the extreme. In addition, the owner has not maintained a large capacity in a manner other than on property owned or immediately controlled by the registered owner. So in other words, it can't leave your property. And you have to prove that it's never left your property. So you have to have, I'm assuming you would have to have video surveillance of every large capacity magazine 24/7, 365 in order to prove that. And maybe that wouldn't even work because you could alter the date stamps on your video. But it does say that if you're the owner in legal possession, you can take it to a gunsmith or gun dealer. You can use it while shooting at a range or participating in firearms competition or hunting or transporting to any of those places. But how do you prove that the entire time you've owned it, that those are the only places it's gone? Just lunacy. Now, this is their kind of the bottom line here now, the Oregon State Sheriff's Association to local law enforcement. To be clear, a person who has owned an LCM for many years and who is using the large capacity magazine only on the property they own and control is still committing a crime and may be arrested and tried. They can of course attempt to prove the affirmative defense applies to them. So in other words, if you're caught with a large capacity magazine, whether you've owned it for your whole lifetime, if you can have owned it for 50 years, and you think that the way this is worded says that it's legal for you to own, you have committed a crime, can be arrested and tried. But in the unlikely event that you can prove that it's been in your possession 24/7, 365 for the entire time that you've had it since this measure went into effect, then you're going to be convicted of a crime for possession of a large capacity magazine. Simple as that. Now, I don't want to give the impression that the Oregon State Sheriff's Association is supportive or complicit in this mess with Measure 114. They've been opposed to it from the get-go, as have almost all the county sheriffs from across the state, except for a few in the deep blue urban areas of the state. In fact, some of the county sheriffs were among the first to sign on with these lawsuits opposing its implementation. And they're opposed to it from not only a philosophical standpoint, but from a practical point as well. Take this county, for example. This is a huge county. It's bigger than many of the states on the West Coast, with a very small staff to enforce laws in this county. They don't have the time or the resources or manpower to deal with all these permits be coming in with 8 different hoops for the permittee to jump through. And they certainly don't have time to go out and make arrests for people who, say, have owned a Model 12 Winchester shotgun for 50 years and are shooting it on their own property, and they don't have no interest in doing that either. So the Oregon State Sheriff's Association, by this guidance, has really helped to expose how deeply flawed and unworkable this ballot measure would be if it were to be put into effect. And I think that helps our cause tremendously. Now, I want to speak to something else really quickly. One of the things that this measure doesn't do is make it any more difficult to sell a gun into Oregon if you're an outside seller. Now, I'm seeing a lot of people, particularly on GunBroker, who are not selling to Oregon residents anymore. And I understand the hesitancy. I mean, I probably would do the same thing if I were a seller, say, on GunBroker. But the reality is it has changed nothing for the seller. The process is still the same. You have no additional risks or hoops that you have to jump through. You sell a gun to an Oregonian, you get paid for it, you ship it to a FFL transfer agent in this state, and your part is done. That the ownership of that firearm has shifted to somebody else. Now, if Measure 114 is implemented and the buyer can't get the permit to transfer from the FFL dealer, that's between the FFL dealer and the owner, the purchaser. So if you're hesitant to sell into Oregon, rest assured there is no additional risk or hoops that you have to jump through. It's just the same as if you were selling to a free state in the United States of America. Well, thanks for joining us today. I hope maybe we filled in a few of the blanks for you. Remember to support the Oregon Firearms Federation and the Oregon State Sheriff's Association. They're fighting a good fight. Keep up the good work and keep up the fight. Until next time, happy trails from the Cinnabar.